This video I'm making to review the immigration law changes brought by 2021. So, immigration law has massively changed the year in 2021. I'm not able to give every single update, every single issue. I'm not able to discuss it, but I'll touch in some major changes which came into force by the year 2021, and including some of the Supreme Court decision which also came in 2021, which massively affect the immigrant, many people, asylum seeker, EU citizen. So 2021 is really tough year for the immigrant, for EU citizen, for non-EU citizen, those who want to come to the UK, or those who asylum seeker, or those who want to seek asylum. Especially for EU citizens, the major changes came in UK legal system in immigration law was the Brexit and the EU settlement scheme. So I'll start first changes from 1st of January 2021. 1st of January 2021 was the major two changes. One, inadmissibility rules for asylum seeker, and the new immigration system for EU citizen. The deadline was 31st December. So let me speak about inadmissibility rules. Now, inadmissibility rule is introduced, which come into force from 1st January 2021 to onwards. That means if it's basically for asylum seeker, or those who will seek asylum in the UK, if they travel through any safe third country. Safe third country means either maybe a EU country or non-EU country. If you have traveled any safe third country, if you travel only in any other third country, and if the Home Office found that you have a connection, you had an opportunity to seek asylum to any third country, the Home Office can declare that your asylum claim is inadmissible, and accordingly they can refuse your asylum claim, and they can refuse back to the third country. For example, if someone traveled from Syria to Turkey and then he by somehow directly comes to the UK or by the Europe, whatever, but he was in Turkey or he was in France. Now, at the time he will landed in UK, either in Juba or either in airport, the Home Office can declare that your asylum is inadmissible because you was in Turkey, you had an opportunity to stay there or seek asylum, but you didn't, and accordingly they will refuse your asylum application on first track basis and then deport back to the third country. Following the year, end of the year, when they're going to introduce Immigration Act 2021, they are adding some provision. Those third country who will not assist Home Office on deportation, then they will impose a visa penalty, which means that the safe third country has to accept the person if the Home Office want to deport. If they don't agree with the Home Office, then they will impose a visa penalty. So this is the first changes which came into force from 1st of January 2021. The second important, I would say the most important changes came in 2020 from the 1st January is Brexit. That means from the 1st of January 2021, the end of the transitional period was 31st December 2020. And from the 1st of January 2021, the new immigration system set up introduced by the Home Office, which is the national immigration law, will apply to the EU citizen. If any EU citizen who hasn't come to the UK, who had come to the UK before 31st December 2020, they are not eligible to come to the UK as a EU citizen, under the free movement right, and they will not able to get pre-settled status or settled status or get any right under EU law. Now, these were the biggest. I'll not discuss much about EU law as many people know about it, but anyway, I gave an introduction because this was also part of changes came into force in 2021. Now, moving to moving to the main issue we as a practitioner are facing in immigration 2021 is not COVID issue. The issue of delay home office decision, whether it's if you say an asylum application, asylum claim, or the substantial interview, or if you say for any types of application, whether leave to remain or spouse visa application, or any form of extension, even naturalization application, the home office taking very significant time to give a decision. Even in anti-clearance visa, where I used to get decision by 2 weeks, 3 weeks, 8 weeks, now they're taking 4 months, 6 months, even 8 months to give the decision. And many people, especially the asylum seeker, are suffering a lot to get to get a decision of their asylum claim. They are systematically, the system make them destitute, and they are ultimately the people who suffer for this massive delay of the home office. Although that they are blaming COVID, but it's not all the cases. Many institutions in the UK work very well without any problem, but only the home office, where immigration and visa department are taking long time to give a decision. And that's what the main issue what many people and we practitioners are facing. What were the surprising changes in the immigration law? And this is a very serious threat for many asylum seeker. That is the national. It's not only for asylum seeker, for an individual citizen, even a British citizen, is the Nationality and Border Bill. Now, the Nationality and Border Bill, which passed through the House of Commons first, second reading, now is House of Lords. More probably will end of January, I think, and maybe in February or March 2022, the Nationality and Border Bill will come into force. But that bill introduced by the current Home Secretary, Priti Patel. Now, the border bill, the national border is very serious. First, couple of provision I'll give some idea. For example, if someone seek asylum in the UK, and if he enter UK through any illegal route, so for example by dinghy or by lorry, immediately this will be a criminal offense. Rather than the asylum seeker taken into the hotel to provide accommodation, they will be taken to police station or prison. The other significant threat for me, as what I find is very difficult, and it looks like very unfair, that if someone in the UK, if someone not extend visa, and if someone become overstay, immediately this will be a criminal offense. This will be an offense. That means if someone in the UK, if his visa expire, if he doesn't leave the UK or doesn't make an application to extend his visa, this will be an offense. And the punishment for this offense is up to 4-year imprisonment. Very rare, very I find it very difficult. And the highest punishment was in under the previous immigration law was 6 months, but I never seen that anyone been prosecuted not to apply for a visa. But it looks like the Home Secretary going to be very tough, setting up very tough rules for so that no overstay can stay in the UK. Everyone has to be apply visa. But looks like many people had no opportunities. So many people, thousands of people in the UK overstay. I don't know how likely that people will be treated, whether the nationality and border bill will be given any retrospective, if it means that those who already overstay in the UK, whether they will be defined as a offense that they are. But so this is an issue, so we need to look into in future. But look like from now on, if anyone not apply for visa after expiry of his term, then he will be considered as an overstayer, and he will be prosecuted for not to stay in the UK after his visa or her visa expire. The National Border Bill also which is introducing the Home Secretary authority to remove or the citizenship, what is a British nationality, can be revoke someone without notice. This is also many people is wondering that most of the ethnic people will face the revocation of their citizenship, because most of the ethnic people got British nationality, that they got nationality from naturalization or by birth, and they have also dual nationality either through their parents or by directly himself or herself. Now, the Home Secretary, under the current nationality law, under the British National Act 1981, the Home Secretary does have authority to revoke British citizenship. However, what the Home Secretary need to do, Home Secretary need to serve a notice to the person whose British nationality will be taken. Under the current, what the Nationality and Border Bill is proposing is that the person British nationality will be taken away without his knowledge, without any notice, without any precaution. That was very concerning because, for example, if your nationality taken, if that you will not know, you will travel to somewhere and you'll stuck on that country over there, and then it will be unlikely you will able to come back to the UK to challenge the decision of the Home Secretary like Shamima Begum. So that's what the other concerning part of immigration, nationality, and border bill. So that's what need to look into it. So these are the couple of changes which brought by 2021, and that there are a couple of decision came from the Supreme Court. I'll give a brief. And last week, I mean, the last month, also some changes come in immigration rules. That is care worker visa, which I'll give a details, a separate visa. That means the care worker, their position is moved to shortage occupation list due to the recommendation of Migration Board. That now the Home Secretary classified the care worker as a shortage occupation list. That means they can come in the UK easily. They need to show only, they need to earn 20,600 pounds. They don't need to earn 25,600 pounds. So care worker, this is the biggest change as well. However, the reason I'm saying that I will make a separate video to make an awareness. Many people in our community are misguided by these changes because they are thinking that if they're old, they can bring a carer from their relatives, maybe their son-in-law, nephew, nieces, to look after them. But this is not the case. The care worker, where the changes come, this is an individual cannot bring someone to look after them. The changes come is that the carer can come, the carer, for example, any care home, if they want to bring any carer in the UK, that easily for them, they can bring, they need a license from the Home Office, and they don't need to pay them 25,600 pound. They rather than they can come under a shortage occupation list. It is more easier, but an individual can't bring. This was misled many people because I did a TV show in TV. Many people called, I want to bring my brother, I want to bring my niece. So this is not the case. Now let me move on the Supreme Court decision, which a couple of decisions I'll refer, which is very important, and this is changes and affected many people. For example, the first I'll tell you the Shamima Begum case, which came in 2021. Now, Shamima Begum has lost on her case in the Supreme Court. That means she will not able to return to the UK to argue her main case about whether she should or should not be deprived of her British citizenship. But her main case remain outstanding and may remain outstanding for a long period of time to come, as we will see. The Supreme Court reached no conclusion here in the final outcome of the case. But initially, what her case was to return back to the UK to argue her case with, so that she can get a fair trial. However, the Supreme Court reject her appeal, and by the way, now her main case will go ahead. Let's see the final outcome, but anyway, she will not able to come. This was the biggest and the most important case in immigration law in 2021. Then I will refer you the case, the couple of cases, especially I'll refer you Fratilla case. Now, Fratilla versus Secretary of State for Work and Pension, this decision came recently, where EU citizen, those EU citizen who move in the UK after the EU law during the transitional period, the question was whether they are entitled to get a benefit, universal credit or not. Now, High Court say yes, and then it went to the Supreme Court. The Supreme Court finally overturned the decision and said no, under Directive 18 of the EU law, that doesn't give any protection for under the EU settlement scheme, because this is a part of EU law. Therefore, they are not entitled to get a protection. Accordingly, those EU citizens who moved to the UK during transitional period, they will not able to get a universal credit or other public fund unless they can prove that they exercise the free movement right prior to Brexit or prior to transitional period. And also, for example, if someone come to the UK work before that, they can entitle because they exercise EU law before the transitional period. There are some exception, but the play very plainly that the decision overturned in High Court. But many people are applied before and they are getting. I wouldn't say that is why they are getting, because the explanation need to be DW. Some people they are getting, some people are not getting, and after this case came, many people applying for universal credit, but the DWP are refusing. So this is one of the most important, because this decision affected every single people who came in the UK from Europe after transitional period, after Brexit. Another case also I will refer, the Supreme Court uphold the policy of asylum seeker to be children if not. So basically the current age assessment policy was challenged, and the Supreme Court uphold that this is the right to uphold the Home Office age assessment policy in the case of RBF Eritrea versus Secretary of State. So these are the case, and then finally I will refer a very recent case last month, which is non-payment of immigration health surcharge, R. Afjal versus Secretary of Home Department in the Court of Appeal 1909. In this case, the Court of Appeal said that if someone doesn't pay the immigration health surcharge, that means he made an invalid application, and accordingly his leave to remain will not get protection under Section 3C. That means this case and this decision is very important. If you make an application to the Home Office, and if you make an invalid application, then your invalid application Home Office can reject, and in that case your leave to remain will not continue. That means you will not get protection from continuously a residence under Section 3C of 1971. So many people, what they do, they wait to complete 10 years, and in some people use the system. What they do basically, for example, they know maybe 6 months left to complete 10 years. So they made an application. They don't give the correct card details to pay the Home Office fee. They don't pay the immigration health surcharge, or they don't attend to the BRP appointment. Even though the Home Office has issued notice, invite them to enroll them in the to biometric residence fingerprint or to attend make an appointment. So if such situation, if you are not comply this notice, if you don't pay the immigration charge, if you don't pay the correct immigration fee on time with the application, Home Office can declare that you made an invalid application. Now, if the Home Office made and declare this is an invalid application, that means you will lose your continuous leave to remain. And what the many people do, Home Office refuses, they do appeal, or they make another application before make a decision. This circumstance, basically Abjal and versus Secretary of Home Department case is relevant. That means if you make an invalid application, your leave to remain will not continue if the Home Office declared that your application was invalid. And final case, again 22. This was a criminal case, but it's an immigration case where the Court of Appeal has decided that the conviction of someone who assists some asylum seeker to cross the channel, and the Home Office prosecute the person who basically assist asylum seeker to cross the channel. Now, Home Office, the Court of Appeal has quashed the conviction of 3 asylum seeker jailed for between 2 and 6 years for assisting unlawful immigration after piloting small boat across the English Channel. Now, the case in Barney and the Crown, this was the case where the court said that if the passenger are not doing illegal immigration, because it is not a crime to seek to cross the channel by boat to seek asylum. This is not a crime. If currently, until it will be crime from after once the big border bill passed. But currently, if someone crossed through the Duba by a dinghy, this is to seek asylum in the UK. This is not a criminal offense. This is not an offense. So if someone assists that person to come to the UK, that is also not an offense. That's what the main theme is. So if the passenger are not doing illegal immigration, the pilot cannot be assisting illegal immigration. As I said, that currently the law stand is not an it is not an offense. However, to tackle this issue, the Immigration and Border Bill, which is will come in force from probably end of February or March this year. At that time, this is if someone enter illegally in the UK, that will be a offense. And if it is the offense, then if someone assists cross the channel, that will be also an offense. But right now, the Court of Appeal quashed the 2 persons' conviction on the ground that if the passenger are not doing illegal immigration, pilot can't be assisting illegal immigration. So as I said earlier, this is very interesting case, an important case. Many people were prosecuted for assisting legal immigrant. Now, if someone crossed the channel to seek an asylum in the UK, that is not an offense, and accordingly, if someone assists, if the pilot cannot assisting illegal immigration. So these are the couple of cases in UK. Another case also stateless admission, which is RAZ versus Secretary of State. This is a stateless application from a Kuwait Bedouin case. I will give a details outcome, detailed discussion about in a separate video. But what the outcome of this case was that if someone have visa to return back in the country where his residence, that means he is admissible on that country. So one Bedouin from Kuwait, she came to the UK. She has visa, temporary residence permit to go back to the Kuwait, but she made an application on a stateless. The question was whether she is admissible to the Kuwait or not. The court said yes, she is admissible. Appeal court said she is admissible, and under the immigration law, if someone is admissible, then she cannot be make an asylum claim in the UK as a stateless person. So this Bedouin position was she had a permit to return back to the Kuwait. Therefore, she was admissible, and accordingly, under this admissible rules, her stateless application was refused, and accordingly, the court explained what is admissible in this case. So these are the couple of issues and couple of update what many people. This is the basically the headline what I'll say in the case of immigration update 2020. So many people make comments. I'll take some important question, and then inshallah I'll give the answer. Let me see the first question. Nantuna Kuti, any news Court of Appeal Zamrano? Thank you, Kochi, for your comment. We don't have any update yet for Zambrano because the Zambrano application is still pending in Court of Appeal, so we need to still wait. And I do believe it will take long time because currently the court, as the because of course COVID makes law, and in the Court of Appeal, it take a year to get the first permission hearing. So it has not listed yet. Once this hearing listed, then they get the permission to appeal, and once the Court of Appeal give decision, then the Home Office will change their policy. So it's the right current position is we need to wait from the Court of Appeal. Zambrano, many people know it, but I'll not discuss much. Just this one. The next question. Russell Ahmed, my visa vignator, my name is Rasi Ahmed, but my name is Rasi Ahmed. The one of the mistake of my name spelling, I already booked my ticket now because of date my TB test expire. Now what I can say, Home Office to give me a letter, I correct it when I came to the UK will give. Okay, I'm not sure if your visa, if your name is not spelling is not correct, whether that the airlines company will let you to travel or not. This is entirely depend on airlines agency. So it is important you first check with the airlines. You to book a ticket, I think you should speak with the airlines customer service, because this is not whether the Heathrow airport will give you entry. This is the first you need to think when you left your country immigration officer will look into whether you have a correct visa or not. Now if they find that name is not correct, maybe they will not let you to travel. So this is an issue what you need to speak with the airlines and your local immigration authority. But this is I'm doubt about your circumstance. Next question. What is going with the application of 2020? It's not clear. Some people are like 8 months waiting without answering from Home Office. This was my discussion. I initially discussed about it. That the biggest challenge we face in Home Office in 2021 was the decision making time, because Home Office taking so long time. Normally, even I say an example, even for anti-clearance visa, we used to get a decision within 1 to 2 months. Now they're taking even 4 months, 6 months. So this is the current situation. I think if it is 8 months, very significant, you should take a step. The step you should take is to speak to for your local MP. Ask MP to send an email to the Home Office and ask them why they are making this delay. You should send an email to the secretary of your local MP. They will respond your email. Okay, ABCD. If I don't know how's your correct name, that's what for you. Any update or changes on the 20-year route? No update. Paul McDonald. If someone in the UK for 20 years, if someone can prove that he is in the UK for 20 years, you can make an application for leave to remain under human rights, private and human rights. What update I can give you is, it's not a good news. The current Deputy Prime Minister, who was Foreign Secretary before, he is proposing to reform the Human Rights Act to 1991. So 20 years rules is under Article 8 of Human Rights Act 1998. So they want to change to deport people from the UK more easily to protect public and national security. Now, if the government reform the Human Rights Act 1998 and they want to bring Bill of Rights, in that case might be the rules like 20 years rules, 7-year rules, half of your life rules, significant obstacle rules. These are all human rights rules where someone can claim leave to remain under Article 8. That types of rule will be relaxed and maybe they will change. They could refuse your application. Also, as you know, that current immigration and border bill criminalize and overstay. That means if you don't have visa in the UK, you will be considered as you did an offense, and accordingly it will be under immigration rules 320 suitability requirement. They could, well, you commit an offense and accordingly we refuse your application under immigration rules 320 on suitability ground, good character requirement. So that's what bad news is. I hope that will not come. The next question: how long court take from a day, from the day or appeal? I did an appeal 1st September, 4 months ago. What you think, please? Well, appeal normally it take around 6 to 8 months. 4 months is not much, but I do believe you received acknowledgement of service, acknowledgement from the court. Also, probably, most probably, you have received the home office bundle, because normally within 45 days home office need to send a bundle to the appellant. If you haven't received the home office bundle, then you should contact with the court. Now once the home office gave you bundle, then the tribunal issued direction to send your bundle. So that's what your current position should be. I do believe this is the first year tribunal. And then Stephanie Alexander, thank you Alexander, I think you are my regular viewer. And you said, I have made a Zambrano application since June 13 and still haven't received any certificate application. I've only received a letter of stating that they received the application. Yeah, from the I think from the November, the Home Office started issuing certificate of application. Many people have already received. I'm not sure why you haven't received. If you give a ring to use settlement scheme, they will explain, they will give you, because you have already received a letter and there is a reference number. So you can call them and then they will let you know, because certificate of application will give you right to work. So it is important. You can chase them up, or you can also send an email, because if you go to the Google and there is a, if you write contact EU settlement scheme, the box will come. So if you write on this box, then submit it, they will receive, and within 5 days normally they give a response. I hope that will help you. I did appeal 4 months ago. Exactly how long more you think get to the court? I think another, you need to around 3 to 4 month you need to wait. Habib Rahman, can you explain about care home visa, how to apply, how to contact home care license owner? If you Google, Mr. Habib Rahman, if you Google home office, the UK care home, you will see there is a lot of care home who are willing to hire people from overseas. So you need to contact with them. But remember, for my old viewers, when any opportunity come in the UK to come to for visa immigration, many people misuse this opportunity, and there are middlemen. A lot of people take advantage of it and grabbing money from applicants. So you be careful, and all viewers be careful. Don't pay any money, any cash money to anyone. This visa is free. Any care home need employee from overseas, they need to issue a certificate of sponsor. Once the applicant get the certificate of sponsor, they can make the application. There is no financial requirement, there is no financial transaction. So you need to contact with the care home in the UK and make an application to them. They will check your CB, and if they're happy, they will give you a certificate of sponsor, and then you can come work in the UK. So that's how you can go. Now currently currently a lot of internet make is easy for all of you. Thank you, Stephanie. And then what? Isabel Ghana. Is Sylhet a war zone? If not, why you are coming to the UK? Will you have a bringing enough money to house and feed yourself as well, paying all legal fees? Just asking on behalf of taxpayer. Thank you, sir. Sylhet is not a war zone, and people are not coming from Sylhet to seek an asylum. Many people from Sylhet origin are in the UK and they're contributing the UK economy and paying tax. Many people in the UK are getting benefit from the tax of people who come from Sylhet and making established businesses. Look at yesterday, the Queen, for the notice of Mr. Isabel Ghana, yesterday the Queen awarded how many Sylheti people on that list? Have a look. I'll tell you two-person name: Afruz Mia, Mr. Shiraj Ali, and many more on the list. Okay, I do believe you look into the people of who contribute in this country. I hope you trust chicken curry or chicken tikka masala as well. Thank you, Mr. Isabel, for going up for your command. And then move to next question. Hello, sir. My further submission outstanding for more than 2 years with RCM. I don't know why it's take too long for make a decision. Do you have any information about further submission? Well, further submission generally taking long time, but if it is 2 years, then I think you can chase them up. You can approach to your local MP, ask the MP, explain to him, and he will contact it with the Home Office. 2 years is quite long time. You can write a letter as well to the Home Office and then get a decision, because 2 years long time. And if you can contact with them, maybe they will, because further submission is thousands of further submissions submitted each year now. Home Office are struggling to deal all these further submission, so you need to work on it. But if you just rely on that, they will check and they will get me a decision. You need to wait. Rather than, I'll advise you to contact with the Home Office, write a letter, contact with your local MP, ask your solicitor to write letter to the submission unit in Liverpool, and then hopefully you will get your decision soon. Jonathan, sir, I'm in 11 years of RC. I'm a UK asylum seeker. Border agency card have registered. Home Office given me sticker my choice. I came Bangladesh. Now I am at home Bangladesh. When I'm coming in England, please. I think if I don't know your current situation, why you've been not in the UK, why you deported, whether you deported or whether you voluntarily return. If you leave UK voluntarily, if you're not able to stay, you can come anytime. But if you deported, if you breach an immigration law, that will make difficult. Maybe you can come after 10 years, after once you left the UK. But more likely, Home Office will refuse on suitability ground under immigration law 320 in case if you were in overstay in the UK, if you were breaching immigration law. So I don't know personally your circumstance, and I can't give you exact answer, but it depends on your circumstance. I have 2 years bills and proof. What do you think about my case? Please, when I go to court, 2 years is long. I don't know, my friend, what is your case is. But it looks like probably maybe you will make an application on the basis of a 2-year relationship with a British citizen or a settled person. If this the case, then most probably if you can provide all the 2 years proof of your relationship, and if you take, I'll advise you, I do believe you have a lawyer. If your lawyer can make a good skeleton argument, because skeleton argument is called the legal argument, which is very important, because judge will read skeleton argument before the hearing start. So judge will read it, and when he will enter the courtroom, your solicitor will ask you first a few questions, and the Home Office will ask few questions, and then your solicitor or your counsel will make the submission, and this is what the heart of your case. So skeleton argument is very important. If you have a solicitor, I think might be your solicitor will prepare it, and then hopefully you will win your case. Good luck for you. This is all about today, everyone who watched this video. Thank you very much. This is my discussion was mainly the year review of 2021. This is important year. Immigrant and EU citizen are facing many challenges because of the immigration law changes brought by the Home Office. Now, I will make another video which will explain what we expect, what are the changes we expect in the year 2022. Thank you very much. Please feel free to share this video in your profiles if you want to let the other know about this information. Thank you very much. Good night for everyone.